Hello everyone, welcome to our seminar this afternoon on how to remove a title condition restricting development. So I'll introduce who's going to be speaking today. I'm Matthew Farrell. I'm a partner in the real estate litigation team. I get the pleasure of introducing the speakers and also coordinating the questions at the end. Elizabeth Ward is one of the experts in the real estate team who deals with a lot of development matters throughout Scotland, and Calum MacPherson is a real estate litigator who has litigated extensively on title conditions. So they both have great experience of dealing with title conditions in a development context, and they come at it from slightly different angles. So without further ado, if I could hand you over to Elizabeth.
Thanks, Matt. Good afternoon, everybody. So just to set the scene here, so what type of title conditions are we looking at? As Matt said, I work with a lot of developer clients, BTR, student accommodation, but also retail development, so building out retail parks. And these are the kind of title restrictions that we see coming up that are potentially problematic for development. So the principal ones we see are use restrictions, which are preventing the land being used for certain things such as supermarkets or cinemas or leisure, that sort of thing. We also see height restrictions. That's particularly in city centre locations such as the West End of Glasgow or the new town in Edinburgh, where there's often height restrictions based on existing tenements. We're looking to develop, say, student accommodation higher than that. That can cause an issue. And also sometimes we see on larger development sites, historic access routes, which could cause a problem depending on where you're looking to put your buildings. So they're sort of the type of conditions that we see most often coming up. We're going to be speaking through, or Calum will be speaking through a worked example later on. In that, we're going to be focusing on a use restriction. That is the one that is most problematic. So why are these problematic? A restriction or a title condition in itself is not a problem. It sits with the land. It may not be an issue, but there are reasons why these come up, and there are reasons why clients look to discharge them or vary them to get them off the title. First of all, probably the one we see most often is to facilitate a sale, where we know there's a pesky title condition on the land, and the owner, the client, feels getting rid of that will make it more amenable for a sale, more palatable. There may well be a preferred bidder in the wings that this condition may be a problem for. Linked to that is the increase in the value of a property. A property without that restriction is more palatable for planning, it's more developable, there's a chance it'll be higher increased value for that property, again linked with a sale. To enable development, this is one where I think a lot of our clients come up against, particularly as I mentioned, say student accommodation and the like, or the retail parks, where you've bought a development site and you're looking to develop it out from scratch. So it's a brownfield site, you're looking to put something on it, and that title condition could scupper that completely if it stays on the title. And slightly linked to that is where you have an established retail park, for instance, or an established scheme, and you're looking to perhaps change the tenant mix. So back in the worked example that Calum will speak to, for instance, we used to have, say, an anchor tenant in a retail park, and there's a prohibition on any other unit being used for that same use, and the client then wants to increase their mix of tenants or increase their offering, and they want to discharge it. So it's not necessarily about developing out, it's about changing the use of an existing property. So they are sort of the parameters which we see in these title conditions come up most often. And moving on to the next slide, please. So in terms of the roles between real estate and litigation, and we work very closely together, as Matt said, but what are the different roles that we have? Well, normally the clients will come first to the real estate team because we're the ones buying the land for them, we're prepping it for sale, we're working on the development, we're the ones that are most, at the outset, most knowledgeable about the land. Often they'll come to us, and what we will do is an initial review of the burden itself to ascertain what the burden actually does, what it catches in terms of what the client is looking to achieve as well. Is it going to be a problem? We'll then quite often do a quick check of adjoining title deeds, and that's looking at the Land Register of Scotland for the neighbouring properties. Do any of them have the same burden? Do any of them have the same title condition in their titles, as that may well mean that they have the right, potentially have the right to enforce it. So that's what we're trying to identify. We also do a brief analysis on whether it survived the recent Scots law changes, and this is in relation to the abolition of feudal tenure, where very old burdens could have been extinguished. It's a very prescriptive test for that. It's quite a detailed analysis we have to go into. It's not carte blanche, so if it's an old burden from 1760, you can automatically ignore it. Unfortunately, that's not the case. I'd like to tell you that it is, but it isn't. So we then have to analyse it to see whether we feel whether or not it could still have survived those changes in the law. At that point, we'll have our initial analysis, we'll have discussed with the client, and if there's any risk that that burden is still live or is still enforceable, at that point we then need to go into the in-depth analysis, and that's where we turn to our property litigation colleagues, because they have the very in-depth experience of removing these. And at that point, I will usually hand over to my colleague Calum, as I will do just now, and he'll speak to the in-depth analysis that the litigation team does.
Thanks, Elizabeth. When one of these cases is passed to us, the first thing we do is carry out a forensic analysis of the burden in order to establish whether or not we think the condition is enforceable and valid. The law surrounding title conditions is complex, and not all conditions appearing in titles are valid and enforceable. One of the things we'll consider is in relation to validity is whether the condition is contained within the four walls of the deed. To validly create a burden, the full burden must be found within the four walls of the deed. Therefore, if a burden states that a property must be used in accordance with a piece of legislation, or it requires you to refer to another title deed to fully understand what is required, the burden is generally invalid. Another thing that we take into account is the sunset rule. So if burdens are more than 100 years old, there's a fast and simple procedure for having them removed. However, there are certain burdens which are unfortunately excluded from this rule, such as facility burdens. So what can you do if a burden is more than 100 years old? In those circumstances, the owner of the burdened property can draw up a notice of termination, which is in a statutory form. And a single notice can be used for any number of burdens, and that allows all burdens of more than 100 years within one title deed to be extinguished through one process. The notice is sent to the owners of all benefited proprietors within 4 meters of the property. So that's a fairly small proximity. It only needs to be sent to the benefited proprietors within 4 meters. In respect of intimating the notice on the other benefited proprietors, it's sufficient to fix a notice on the burdened property and on an appropriate lamppost. So again, that's pretty helpful because often those lamppost notices are overlooked. Benefited owners then have a minimum period of 8 weeks to object by applying to the Lands Tribunal for a renewal of the burden, so the onus is on them to make that application. And if no application is made, the notice is endorsed with a certificate by the tribunal, and then it can be registered, and it's on registration that the burden is extinguished. Another thing that we consider is title and interest. In relation to enforceability, for a burden to have effect, it must be imposed on the burdened property for the benefit of another property. You should consider if there is a benefited property. If no one has title to enforce it, generally the burden can be ignored. If someone has title, you must then consider if they have interest. The test for interest is prescribed in the Title Conditions Scotland Act, and that Act states that a benefited proprietor will have interest if, in the circumstance of any case, failure to comply with the real burden will or is resulting in material detriment to the value or enjoyment of the person's ownership of the benefited property. So you should carefully consider if this is the case. Is the detriment material, or is it just slight? If there's any doubt in relation to that, then you should consider one of the options that Elizabeth is about to discuss in the next slide.
Thanks, Calum. Yes, so once we've been through the process of our analysis, if our view is that that title condition is valid and it is enforceable, what are the options? There are actually a number of options here, and again, with most things, it depends on the client's view on timescales. Do they want a quick fix, or are they looking to, do they have time in order to deal with it? Is there a cost? Do they have a budget for dealing with that? Because that can influence which decision we do, and also the actual risk and importance following our analysis. And at the initial stage, they may think it's a big risk. Following our analysis, that may have changed both ways. It could no longer be a risk or it could be a higher risk. So depending on that, there are various options. Insurance, title indemnity insurance, and as we all know, insurance doesn't fix the problem, it just enables a payout should we need to rely on it. There is a market for this, and there are insurers that will look at risks, and the premium will depend on the likelihood of the risk, likelihood of the insurance paying out, but also looking at development sites, the overall development value. So please bear that in mind. It's not necessarily the land value, it's the overall development value. So insurance is an option. The other option is another option is to obtain a discharge from the benefiting owner. This is possibly the highest risk option because, as we all know, if you go to an adjoining owner and say, you've got a title condition that I'd like you to get rid of, the chances are they'll prick up their ears and possibly hold out their hand and ask you for a check to deal with it. It also puts them on notice. So this option would only be essentially one of your last resorts. If you alert the other person to the fact they have an enforceable condition, insurance goes out the window because you've already alerted the person who can enforce it, and some of your other options may not be available. However, when you are looking at obtaining a discharge from the benefited owner, think about whether there's any commercial aspect or commercial leverage. We had one where clients owned a retail park, there was a supermarket next door with a use restriction. We wanted to change the tenant mix. We wanted to try and get rid of the use restriction. We were going to look at all the various options. And I remembered from acquisition that our clients owned a small part of the adjoining access road that wasn't publicly adopted. So we essentially had a bit of a ransom strip, and we could use that as a negotiation tool. And we ended up dealing with the burden that way by essentially transferring over the access road in exchange for a discharge. There may be options in terms of speaking to the other owner. Ignoring the burden, if we think it's low risk, we could just ignore it and hope for the best. There's also the negative prescription, and that applies where if a breach has occurred and it has not been challenged for the period of 5 years after the breach occurs, then the burden in relation to the breach element only is deemed to have gone away. But please be aware that that would only apply to the bit you've breached. If there are various parts of the title condition, they don't all fall away, it's just the breach. Again, that's got a time period on it, it's 5 years, and you're relying on nobody enforcing it. Rely on acquiescence, and Calum just touched on this before, where if you've incurred material cost, for instance, and the existing breach has not been challenged, that could be seen to apply in that the other owners have essentially acknowledged there's a breach but not done anything about it. The type of thing we're looking at here, for instance, is if there's an existing breach or has somebody else breached it. We saw that with one of our clients where there was a height restriction, but one of the owners nearby who had the same title condition and could have potentially enforced it had already developed out for higher than the title condition, the title restriction. So suggesting that there was an appetite in the area for people not to enforce. Two wrongs don't make a right, but it just helps back up our position. And also in looking at relying on acquiescence, has a planning permission gone in? Because planning permissions include neighbour notification, so people would then be alerted to the fact that your development is potentially going to breach the title condition. It all just adds weight. I appreciate these are options that all have a bit of risk in them. It still means for all of these that the title condition still appears on your title sheet. And if you're looking to sell, that can be an issue because you have to persuade a purchaser that for the reasons that we've just discussed, they don't apply. So the most cast iron way of getting rid of it completely, other than discharge, is to go to the Lands Tribunal. And that's where, again, we bring in Calum and the team, and he'll talk you through the process that we go through there.
Thanks, Elizabeth. So as Elizabeth just mentioned there, if none of those options work for you, then you are left with no other option than to raise an application in the Lands Tribunal. So if we can move to the next slide, please. The first thing to consider when going to make your application to the Lands Tribunal is whether it can be made at that stage. The deed may provide that no application for variation or discharge can be made before a specified date after its creation. Now, the legislation states that the specified date cannot be more than 5 years after the creation of the title condition. If no such provision is contained in the deed, there will be no time restriction on the application. Or if the time restriction has passed, then again you can just crack on and draft and lodge your application. Another thing that's important to consider when drafting your application is that where you're seeking an order for variation or discharge of a title condition, if that application is undefended it will be granted as of right. In other words, the tribunal will automatically grant the application without needing to hear any submissions or having any hearings on the matter. This is important to bear in mind. Other applications, such as an application on the validity of a real burden, are not granted as of right, and they require a determination by the tribunal, and often hearings and written submissions, etc. So, as an aside, when faced with an application on the validity of a burden, it may therefore tactically sometimes make sense to raise an application for variation or discharge to avoid the cost of having to deal with hearings, etc., on the validity, and perhaps more importantly, potentially having a negative judgment found against you. If the application is defended and you've gone down that route of seeking variation or discharge instead of an order on validity, you can always amend in a request for an order on validity at that stage. So back to the application for variation or discharge. As they are granted as of right if undefended, we normally advise clients to make an application as compelling as possible to dissuade any benefited proprietors from defending the action. So what do the Lands Tribunal consider? If we could move to the next slide, please. In terms of Section 98 of the Title Conditions Scotland Act 2003, an application for the variation or discharge of the title condition shall be granted if the Lands Tribunal are satisfied, having regard to the factors set out in Section 100, that it is reasonable to grant the application. So I've copied most of the factors under Section 100 on the screen there for you to see. You'll see they include any change of circumstance, whether the title still confers benefit to the benefited property, whether it impedes the enjoyment of the burdened property, how practical or costly compliance is, willingness to pay compensation, the length of time that has passed since the creation of the burden, the purpose of the burden, whether consent from planning has been obtained, the restricted use, and a catch-all, all other factors which may be material. So if we could move to the next slide, please. I've taken a quote here from George Winby versus Fleming, and that states that Section 100 does not require consideration under each head of whether the application succeeds or fails under it. Rather, the task is to look at the evidence about the various factors and then weigh them up as a whole, judging not as it were the result under each factor, but rather the relative strength and weakness in the overall issue of reasonableness in the circumstances of the case of the various items of evidence in relation to the factors set out in the section. So in other words, it's not a box checking exercise in which each of these factors are looked at in isolation. Instead, the tribunal must consider all of the factors which are relevant to the specific case holistically when considering whether it is reasonable in all the circumstances to grant the application. And if we can move on to the next slide, please. I've copied here a quote from another tribunal case, Ordby Mashford. In that case, the tribunal stress that they tend to prioritise the purpose of the title condition and view the other factors through that lens when making their determination. So they said there that we are satisfied that the purpose of the title condition, if it can be identified, will tend to carry weight. It will always be likely to be of greater significance than, say, the length of time which has elapsed since the obligation was first imposed. If the original purpose can still be achieved, the period of time which has elapsed may be of little significance. On the other hand, if the original purpose can no longer be achieved, the time may be a very minor consideration. Purpose is also of considerable importance in attempting to assess the significance of evidence of change of circumstances. Change will be of little weight unless it can be shown to be relevant to the obligation. Reference to purpose or intention will also play a big part in weighting the impact of the removal of the obligation. So that really hammers home that purpose is probably of paramount consideration when considering the different factors under section 100. If we could move to the next slide, please. So to illustrate the Lands Tribunal process, I thought it would be best if I give an example of a common restrictive condition we faced and the steps we've taken to remove it. So in this example, 20 years ago, a developer, when looking to attract an anchor supermarket to a retail park located near a city centre, was pressured to accept the supermarket's demand that all of our retail units within the development are burdened with a restriction which prevents them from being used for the sale of food and beverages. So you've got a retail park, anchor supermarket, and all other units are restricted from being used for the sale of food and beverages. That may have been all and well 20 years ago when there were only a handful of supermarkets monopolising the market and a lot of big names to fill big box retail units. But the market has drastically changed since then. There's a lot of different types of supermarkets which may not be direct competitors, and it often makes sense for them to be grouped in one park. And as I said previously, there's not the same market from the big box retailers such as Toys R Us, etc., which used to fill these parks. So if you have that type of condition and you want to secure a new tenant that has been prevented by it, how should you go about preparing your application to the Lands Tribunal? And if we could go to the next slide, please. The first step we normally take is to gather factual information to support the factors that the tribunal need to consider. To get that information, we normally instruct a planning expert. They are all well versed in producing reports in favour of planning applications, and producing this type of report is a fairly similar exercise for them. So with this example, we'd normally put an emphasis on seeking evidence in support of the factors that are up on the slide at the moment, but all factors should be considered in relation to each application. So first of all, I'll consider purpose. As mentioned previously, you should focus on the purpose of the burden and view the other factors through that lens. Why would the burden restricting other supermarkets or other food and beverage outlets have been put in place? That was likely to limit competition and ensure the commercial viability of the store within the development. It probably was not to create a monopoly. Bear that purpose in mind when considering other factors. The purpose of the condition may also impact the type of application that you seek to make. If the purpose will be less impacted by an application seeking a variation, so in our example, seeking a variation so that only one other unit can be used for the desired purpose, rather than all the units within the development, then it may be wise to make that kind of application for a variation in relation to one unit, rather than seeking a discharge of the burden so that it no longer applies to all of the units within the retail park. Another thing to bear in mind is change in circumstance. When considering change in circumstance, you should look for evidence which supports a change in the neighbourhood, such as an increase in population. Ideally, you'd also look for evidence that the increase in population has not been coupled with a comparative increase in supermarkets or similar stores. New demand in the proposed use serving an unfulfilled market will limit the impact on the commercial viability of the anchor supermarket, which is important when viewing the change in circumstance through the lens of the purpose of the burden. Further, a change in the planning designation of the area would be an ideal change. It may be that in a local development plan, the area containing the condition has been changed since the creation of the burden to, for example, a district centre, which supports that there is a desire for more shops in the area and that the area is not currently being adequately served. Additionally, if the report can support a change in the retail environment, that would also be beneficial. The retail park may previously, as I mentioned earlier, have housed big box units, Toys R Us, etc., which no longer occupy those kind of retail parks in Scotland. And there may be new demand for other types of supermarkets within the neighbourhood, which don't necessarily conflict with the purpose of the burden, as they serve different parts of the market. So thinking of Lidl, Aldi, Poundland, Food Warehouse in the Range, those kind of brands may not directly compete with other sort of larger supermarkets, which we may conventionally think of.
Yeah, I think that's a really good point, Calum, because I think even just the last 2 years, we've seen the huge change in retail habits, particularly with the pandemic, where people now are not necessarily going particularly for clothes shopping to retail parks. And we see a big change towards making them more destinations. So where it used to be purely retail and a supermarket, people are now looking for a bit of an experience. So we're looking at cinemas or restaurants going in, but also shopping habits have changed even just in relation to retail. People are quite happy to do a bit of shopping at a discount retailer for some of your more standard goods and then go to the high-end retailers such as Sainsbury's or M&S Food to get sort of their nice lunch and that sort of thing. So I think that's all very interesting when you look at the way that the retail's going, and we see that with a lot of our clients, the significant change in the shift of habits just even in the last few years.
Yeah, very, very true. Another consideration which the tribunal take into account is the extent in which it confers benefit. So what kind of information would you look for there? You can use the information that we've already alluded to in the previous sections to downplay the extent to which the condition confers benefit on the benefited proprietor. So a big increase in population would likely mean that there's capacity for more than one similar store without adversely impacting trade. We would also usually obtain a list of comparable retail parks with more than one supermarket in Scotland. And that's just to give real-world examples of cases in which multiple supermarkets are thriving within one retail park of comparable size and vicinity to the city centre. So examples like that support that the restriction can be lifted without impacting the commercial viability of the anchor store. Again, harking back to purpose when considering this factor. Indeed, it may also be that the proposed tenant's business would complement the anchor store and add to the trade. If, for example, the proposed new store specialises in frozen goods, and this is quite similar to what Elizabeth just said, that may drive customers to the retail park as there will be one destination for all needs, thus benefiting all parties involved.
I think that's really interesting, Calum, because we've also seen almost the flip side of that. We had one where it was an urban setting. It was an old title condition preventing the use of a bit of land for a cinema, and that was to benefit two other cinemas, and those two cinemas were pretty much across town from where this bit of property was. And when you're looking at the conferring the benefit in the however many years since that title condition was put in place, the cinemas that benefited from it had cinemas far closer to them than our client's property. And I think, if correct me if I'm wrong, but I think that's a good sort of live example of how population changes, cities can change, and the benefiting cinemas, whether our client's property changed the cinema or not, actually made no difference because he had competitors far closer than our client.
Yeah, definitely. No, that's a great example. Thanks, Elizabeth. So we've got 3 other examples to run through, which we'd focus on in this example. But then the next one is the extent into which the burden impedes the enjoyment of the burdened property. Again, here I'd use the information from the report together with the factual circumstances which led you to make the application, to support why the restriction is negatively impacting the burdened proprietor. So, for example, the only tenant willing to rent the unit in question may be restricted by the condition, which is losing you rent and incurring you rates liability, which is a pretty black and white example of it impeding enjoyment in a commercial development. Another consideration is planning. If there is any consent or deemed consent from planning, that will be helpful, but again, it's not determinative. The holistic approach is taken. So by checking that box alone, it doesn't mean that necessarily the application is going to be granted. In relation to other factors, this could be anything and will depend on the specific facts in your case. But in our example, we put forward a competition law argument. So if we could move to the next slide, please. Section 2 of the Competition Act 1988 provides that agreements which may affect trade within the UK and have as their objective, or affect the prevention, restriction, or distortion of competition within the UK are prohibited and void. Now, that's known as a Chapter 1 prohibition. When this Act originally came into force, it did not apply to land agreements. However, that has changed since the coming into force of the Competition Law Act 1988 Land Agreements Exclusion Revocation Order 2010. The impact of that repeal of that order was to enable land agreements to fall within the ambit of the Chapter 1 prohibition. So in our example, we've given the burdened property is being prevented from being used as a supermarket, and therefore it can't compete with the benefited property. So in those circumstances, we normally reserve the right to make a competition law argument in relation to the Chapter 1 prohibition, and in particular reserve the right to undertake and produce reports for the purpose of seeking to establish that the title condition is an agreement between parties which affects trade within the UK and has the effect of preventing, restricting, or distorting competition within the UK.
And certainly from the real estate perspective, we've heard historically certain entities, some supermarkets would essentially land bank to try and prevent other supermarkets perhaps buying that land in certain areas. So this was, from the pure real estate point of view, a bit of a game changer. It really made people go back and look at things. Now, the competition law aspects are very technical, and we would generally bring in our competition law colleagues to help us advise on that. There's a general rule, particularly when you look at monopolies, that do local people have an option? Can they go to a different supermarket with a similar kind of distance for travel and that sort of thing? So on that basis, it can be very much location specific. If you're looking at a city centre, your neighbourhood that you're assessing could be 2 or 3 city blocks. If you look at a more rural setting, it could be potentially 100 miles, a much larger area. So there's no hard and fast rule here, but it's very much looking at the local area. And in our example, did the residents nearby, could they get to another supermarket in the same distance it would take them to get to the one in question? So it's something to always be aware of. But for real estate, it has certainly brought this very much to people's attention, and it is something that is looked at quite often. In some of the ones that I've mentioned in our examples, 1 or 2 of them, we looked at the competition law aspect before then looking at other options as well. So it is something to bear in mind.
That's great. Thanks, Elizabeth. If we could move on to the next slide, which is, I believe, the last slide. Once the application is lodged, it is served on the benefited proprietors. So if defended, there will normally then be a period for written representations, and then a site visit followed by either a hearing in which oral submissions can be made, or it may be that you go straight to determination. The tribunal put a lot of emphasis on the site visit. If it's clear the retail park needs new tenants, as there are empty units, tenants of poor quality, this will likely bear heavily on their judgment. So once that site visit has taken place, as I mentioned, there's normally a period for either oral submissions or just resting the case on your written submissions, and thereafter you eagerly await the judgment. And once that judgment is received, hopefully it will be a favourable one and you've been granted the variation or discharge that you are after. And when does that then become effective? It becomes effective on registration. So it's once you've got the order and you've registered it in the land register or the register of Sazines, the title is then cleaned of the delinquent burden, and you've completed the process. So with that brings an end to my side of the presentation, and I'll pass you back to Matthew if anyone has any questions.
Thanks, guys. That was incredibly interesting. I think the example being one that we actually had worked through before, and it's one that we've seen a number of times. So it's actually very relevant. If I could do a quick summary of essentially what was discussed. It's a collaborative exercise between the transactional and the litigation team. The starting point is commercially, what does the client want to achieve? Is there a way of achieving that without having to have a fight? This includes insurance, speaking to the other side potentially, but you have to be aware of the tactics of doing that, the strategy. You can undermine your position by approaching the other side. If the decision is taken that we need to get rid of the title condition to realise the development potential, you look at the title condition to see whether or not it's valid. There's a number of different factors in that. If it is valid, it's within the four corners of the deed and so on, you consider whether or not you apply to the Lands Tribunal. If you're going to be successful, do you go for discharge or do you go for variation? And when you're at the Lands Tribunal, the question, as you put quite clearly, Calum, that the Tribunal will ask is, through the prism of the purpose of the title condition, is it reasonable to discharge it? Does the title condition still fulfil its purpose or does it not? And often that question will be determined by the change in circumstances. So in our example, we had a retail park with an anchor supermarket, and what had changed over the years were the number of people in the surrounding area, because the number of houses has increased, but the number of supermarkets hadn't increased. So while that title condition was put in place in order to ensure the viability of the supermarket at first, that was no longer the purpose of the title condition, or that purpose was no longer being met because there were so many people who had access to only one supermarket that the supermarket was essentially in a dominant position. But we needed to get a whole load of planning information and information about the number of people to determine that. So the Lands Tribunal will look at that, but it will also look at the benefit and the burden of the title condition. And so the main things are purpose, benefit, burden, and change in circumstances. There's some questions in the chat board. I've got one for each of you, if you don't mind. Calum, first of all, what happens if you just go on with your change of use? So you use your supermarket example. What happens if you just put in the food warehouse into the unit despite the restriction? What are the risks or what are the potential consequences?
Thanks, Matt. So I suppose the potential risks in relation to just cracking on, so ignoring the burden and going ahead with your plans are twofold. So there's the risk from the benefited proprietor. They may seek to lodge an application with the court preventing you from proceeding down that line, an application for interdict, and they may also seek damages against you for any loss they incur as a result of your breach of the condition. And then the second arm of it is that the tenant could also make a claim against you. So if the benefit proprietor lodges that application, stops you from acting on the condition, and the tenant can therefore no longer trade, then depending on the conditions within the lease, you may be found liable from any loss resulting that the tenant incurs as a result of that actions. So really it is a twofold potential for issue we would strongly recommend you address the issue head on rather than just ignoring it.
Okay, thanks, Calum. Elizabeth, in terms of the transactions that you're seeing in the purchase and the sale of land that is affected by these title conditions, whether it's a retail park or just an empty plot of land, are you often reporting on them, and does your report affect sometimes the price that people are willing to pay, or do they generally just accept it as what comes with the land?
Yeah, Matt. So first of all, yes, we would report on those. You know, as our worked example that we've spoken to, 20 years ago, one thing was acceptable, and 20 years down the line it's not. So even within a short period that we've seen over the last few years, buying something 5 years ago, people may have accepted it, they might not now. So we always report on those, because irrespective of what our client is currently planning on doing with that bit of land, things may change. You know, we've seen it with financing. They might need to dispose of it. They might need to deal with it. They might want to develop it. So we would always report on that. We would always bring it to the client's attention, because irrespective of their current plan or the current use or what they may want to do, it is a restriction on the title. In terms of the impact it's had, yes, we do sometimes see that be a reason for potentially a price chip. You and I have had one where we were asked to get rid of it. We had a title condition which was a use restriction. The buyer, their plan for the land was to change the use themselves, so it didn't actually affect our seller clients, it affected the buyer. So as part of making sure that sale happened and not losing the buyer, we actually went through the process of varying that title restriction. So it can depend, and it comes back to what we're saying sort of right at the start. Sometimes clients look at the title before they sell and think, actually, is it worthwhile just going through this process, getting rid of that, because that may facilitate a sale. So we see it in all circumstances, but the bottom line, Brodie, is yes, we would always want to flag it to our clients.
And interestingly, in the example that you mentioned, there was a real tactical decision to be made about whether or not, and Calum, you talked about the decision when you were going through the process. Do you seek to an order that the title condition is invalid and unenforceable? If you do that, you potentially tip everyone off, or do you make the application in the hope that it's undefended and you get it as of right? Because sometimes the application can come in from the Lands Tribunal to the person who's got the benefit of the title condition, and it goes to the bottom of the pile. And if they don't answer it in time, you get your order. So tactics are always important in that situation. Some questions that are not mine. I think, Elizabeth, this is for you. In practice, how often do owners use insurance to protect against burdens restricting development? How easy is it to obtain that insurance, and is it usually pretty expensive or cheap?
So insurance, we do see that quite often as it comes back to and this is a very unhelpful answer, slightly, it kind of depends on the burden and what you're looking to do. We have seen it where, yes, we have gone for insurance a number of times. I think in terms of the burdens I've seen that are an issue, if you want to call it that, I've probably seen an equal balance just about between working with your team in terms of varying or dealing with it through the Lands Tribunal versus getting insurance. It slightly depends. In terms of availability of insurance, yes, there are insurers out there, some who are willing to take different degrees of risk. To date, and this is just my own professional experience, I have not had yet a title condition that we couldn't get insured, but that is just from the very small basket that I've seen. But in terms of the premiums, they can be quite high. Again, depends on the risk, and as I said, it also depends on what the restriction is. We had one we got insurance for, which it was a height restriction in an area with a lot of tenements, and the clients were looking to build quite significantly higher, and that was seen as quite risky. And we did eventually put it in place, but it was quite a challenge to do so. Some of them are less risky, so I would never guarantee you can get insurance, but my personal experience from the ones I've done is we have been able to do it, but it has been quite tough sometimes. In terms of the premium and the value, it can depend. If it's a development site, it's usually you'd want it for the development value, because that's ultimately your potential loss, and it comes down to the client. What are you looking to insure? Have you got SI costs? Have you got legal fees? Have you got planning and consultants costs? What have you spent on this bit of land that you may lose if that title condition is successfully enforced against you? So I appreciate that's not very helpful, perhaps not a helpful answer, but these are all the kind of things to think about in terms of, do we go for insurance? Depending on what the risk is, it may well be insurable, but it's never cast down that it is. In my experience, there'll be possibly others out there in the market or in the profession that have had different experiences.
Yeah, and I think we're not underwriters, but
No.
it's a risk conversation. And I think one of you can contrast, for example, the example that Calum gave, which was a continuing risk because the lease could always be stopped at any point by enforcing the title condition, whereas if it's a development that you're building out, almost once the build is done, your risk reduces significantly. But your risk during the build is probably pretty substantial, with damages that the contractor can enforce against you, or late delivery of something, depending on if you're developing for someone. So yeah, it's very much the facts and circumstances will dictate what the cost is, because they will dictate the risk.
And on that, Matt, we've seen that when we're looking at pure development sites, one thing that the insurers often ask is this pre or post planning, because if it's post planning and you've got your planning permission in place, you have gone through the planning process, you've gone through the neighbourhood notification process now, whether the neighbourhood notification was put at the bottom of the entry or not, but you have gone through that process. And I had one where I could say to the insurers, we've gone through planning, here are all the objections, not one of them, or very few of them actually refer to, say, height in the situation, and none of them refer to the title conditions. So it's where are you in the process? Post planning is often easier for insurers to look at, because and again, we've got the argument of a bit of acquiescence. You've had material cost as well, all your planning stuff. So it just helps stack up.
Perfect. Two more questions then, I think, in that I'm conscious of time. Calum, is the willingness of the person who's burdened by the title condition to pay compensation relevant?
So compensation certainly is one of the factors that the tribunal have to consider. Where granting the order is going to cause substantial loss or disadvantage to the benefited proprietor, the tribunal in those circumstances will be more inclined to grant the application if you're willing to pay some form of compensation to sort of redress that loss. So yeah, it certainly is something that you should bear in mind.
Just working out the loss is probably pretty challenging, isn't it? You know, with the supermarket, how much money they're going to lose by not having a dominant position. Okay, last question, which seems quite a particular question, very interesting. What additional factors would you have to take into account, and this is probably for both of you, and include in an application where the condition appears in a number of titles, for example, a tenement, or in, let's say, a housing estate, which is an area in the housing estate which is held on a pro rata basis?
Yeah, so that sounds like you're verging into sort of community burdens, where the intention is that it is there for the protection of everyone. So that's quite often, you mentioned housing estates, you can often see it where a certain area of land must always be amenity area, like a children's playground or something. So that can be quite tricky to look at. I think on that one, from the real estate point of view, you'd look at, does everybody have the same burden? Is it identical? Is there, and it comes back to the point, you know, from the outset, what's the purpose of it? But I think that's something it could be tricky, and I sort of have to defer to Calum in terms of looking at the intricacies of that. But yes, we have seen it, but
I think, as I think you're alluding to there, Elizabeth, all of these conditions will need examined, and then the sort of surrounding factors particular to that condition, sort of the lay of the land, will need to be analysed with a focus on the factors set out in section 100. With community burdens, one additional thing to bear in mind is that there is a prescribed process for getting rid of them, which is different to the process outlined in this presentation. If you've got a benefit proprietors within 4 meters, I believe you can obtain a written discharge from them, and then intimate it through a prescribed route, which involves posting it on a lamppost, etc. And then thereafter, if no one objects, sort of similar to the sunset rule, you can lodge the notice and have it certified, and then get once the tribunal done that, you can have it registered, which extinguishes the burden. So I think, yeah, if you come across a community burden like that, I think it's quite important to take advice and to get your head around the sort of technical aspects of the Title Conditions Scotland Act and how it applies to that burden, to see if there is any other routes that can be taken that aren't the conventional ones.
Great. And just to add to that, if you're going to the Lands Tribunal, it's the same factors that have to be taken into account in terms of it's the same test of the same items that the Lands Tribunal have regard to, but perhaps it's just easier to show benefit and burden when there's a whole number of people that are affected by it. And so your application becomes a lot harder and potentially a lot more expensive if you have 40 people turning up to oppose it. Okay, I'll leave it there with the questions. All that's left is to say thank you, Calum and Elizabeth, for your time. That was a great presentation and I thoroughly enjoyed it. Thank you.
Thanks, Matt. And yeah, thanks everyone for attending.
Thanks everyone. Bye-bye.